So we move into the equally exciting and challenging tasks of looking at the Clinical Establishment Act 2010, which to me in itself is a landmark act. It is an excellent piece of work, and I would like to call upon for joint session 3, the Clinical Establishments Act 2010, compliments, comments and complaints. The first statute in India to regulate medical establishments, unfortunately is still stuck in controversies. There's an urgent need for all stakeholders in healthcare to discuss, deliberate and understand each other's concerns and positions. The convention hopefully will see some of that happening. I'd like to invite Dr. Anil Kumar, Chief Medical Officer, Nodal Officer at the Ministry on the Clinical Establishment Act to please come on board. I'd like to also invite the following people on board. Dr. Shiv Utture, please come on board, sir. I don't think Dr. Utture needs any introduction. He's an MMC member and has been instrumental in drafting a similar state law in the state of Maharashtra. I'd like to also invite Advocate Balaji Srinivasan, advocate on record of the Supreme Court of India.
Well, thank you, and good afternoon to everyone. And thanks to the organizers for organizing and giving me this opportunity to present the Clinical Establishment Act, which many of you must have read, and also, but some of the perceptions, which I feel that some of the perceptions which are there in the mind of the stakeholders, they may be not actually true, and I would like to clarify some of them to the satisfaction of the stakeholders, and I hope that convention like this, they can bring in the consensus on various contentious issues which are there, and they can, if the amendment is required, if something is to be done about the improvement of this act, that can also be taken up, or something can be done within the framework of the rules that have been notified at the ministry level, that can also be done. But still, let me first present the law, how it is about, what it is about. Because India needs to meet its system goals of reducing the mortality and morbidity, also to bring in out about the equity in the health status and protection against the catastrophic cost, as we were also discussing in the morning, and to satisfy the public. There are mixed situations in India, and the greatest challenge is to ensure a delivery of adequate and affordable health care to the people in our country, especially to the poor. The utilization of services, the 2004 data of NSSO shows that around 78% of the outpatient care and 59% of the inpatient care is being provided by the non-governmental sector. So that is also true. It is growing in a big way. That is good. That is not the problem. But is it growing in a regulatory environment? That is this. Then there is a recently you must have heard about the Operation Jong, in which a TV sting operation showed how the laboratories they were paying commissions to the medical doctors. And that time, even the MCI, the other regulatory bodies, they all said it is only the Clinical Establishment Act which can regulate such kind of a, because they are not laboratories are not covered by any of the statutes that are available. Even they don't have a regulatory council. The MCI said we are regulating only the doctors and not any kind of clinical establishment. So need of the legislation has been well felt, that Article 47 of the Constitution, it mandates improvement in the public health. That has to be granted by the government. There is an unprecedented growth of the private sector, but largely in an unregulated environment. It has remained a contentious and unresolved issue, and majority of the states, they do not have legislations, or they have very outdated and ineffective legislations, and it is a general perception that regulatory processes that are there, they are not adequate. Then how to improve the quality of the care so that the proper health care is provided to the population, that is also a concern. and there is no systematic collection of the information, especially from the private sector. Though there is an integrated disease surveillance program under the National Institute of Communicable Diseases, which is now called National Center for Disease Control, but still the private sector information collection is very poor under that program. So this act was brought in with a view to prescribe minimum standards of facilities so that the mandate of this Article 47 for improvement of the public health can be achieved. And the act was passed in Parliament on 17th August 2010, notified in 2012. There was a National Council notified under the act on again in 2012, and rules notified in May 2012. Right now, the act initially was applicable in 4 states: Arunachal Pradesh, Himachal Pradesh, Mizoram, Sikkim, and Union Territories. And further, the states of Uttar Pradesh, Uttarakhand, Rajasthan, Bihar, and Jharkhand have also adopted the act. I think the definition of the clinical establishment, if you want me to read out, or you must have read it out in the act, that it covers, I can skip, okay. And it covers all the clinical establishments belonging to the recognized systems of medicine, that is under the allopathy is medical and dental system. Under the Ayush, there are 7 systems which are recognized: Ayurvedic, Unani, Siddha, Homeopathy, Yoga, Naturopathy, and Sova Rigpa. Sova Rigpa is the Tibetan system of medicine. So it is covering both the allopathy as well as Ayush. It is covering both the government and private sector. Exception is the establishments of the armed forces. One more thing I want to highlight, that different dates, which is there in the green, that different dates may be appointed for different categories of clinical establishments and for different recognized system of medicine. So that flexibility is there in the act itself. Health is a state subject. It cannot be forced on the state. State has to adopt it under the constitution, and the state has the liberty to decide different dates for different categories of clinical establishments and for different recognized system of medicine as well. So it is expected to lead to a registry of the clinical establishment at national, state, and district level. The Act has provision of 2 types of registration. One is a provisional registration, and which is the initial registration, and that is done without any inquiry and granted for 1 year at a time, and permanent registration, which is granted for 5 years at a time. For permanent registration, the clinical establishment is required to meet minimum standards. So that minimum standards, they have to be defined. Responsibility has been given to a council of councils, which is called National Council for Clinical Establishment, which is a 20-member body, and it has got all important regulatory councils as member of this, as well as Zonal and Northeastern Council, members of paramedical representatives, Quality Council of India, and there are members of consumer groups also in that. So it is a 20-member body under the chairmanship of Director General of Health Services, which has been given the task of categorizing, defining the minimum standards and the statistics that is required to be collected, and publish a national register in the digital form. So for permanent registration, which is for 5 years, the standards are to be met for grant of the permanent registration. One is the minimum standards of facilities and services, minimum qualification of the personnel who would be working in these clinical establishments, then provision and maintenance of records. Certain minimum records are to be maintained by these clinical establishments. Then it is mandatory for clinical establishment to provide treatment within the staff and facilities available. I want to highlight this word, within the staff and facilities available, because there is always a concern that every clinical establishment is required to provide all types of medical emergency treatment. That is not the situation. It is within the staff and facilities that category of clinical establishment is supposed to have. They have to provide that treatment to stabilize the emergency medical condition. Then details of the charges and facilities available, they have to be prominently displayed. So that is also part of this condition of registration. Then they have to have electronic medical records and electronic health records. That is also there. They will charge the rates for procedure and services within the range of rates determined by central government from time to time in consultation with state governments. So that is there, that a range of rate has to be defined for a procedure, and within that procedure, within that range, the charges have to be charged. Then to provide proper health care, compliance to the standard treatment guidelines, which are already there on the website of the Act, they, as may be issued by the central or state government, that has to be done because that standard treatment guidelines, standard protocols have to be followed by the clinical establishment. Then under the Act, there is no imprisonment, only monetary penalties are there. And monetary penalties, they are up to 5 lakh rupees, and it depends on the size, category, type, and location, local conditions of the clinical establishment. Implementation of the Act is not by the central government. Central government is only to make guidelines. Implementation is by the state government authorities. At the district level, there is a district registering authority. At the state level, there is a state council. The district registering authority, the chairman is district magistrate or district collector, and the convener of this committee is district CMO. There are 3 members more to this district registering authority. One is a city police commissioner or a SSP or a SP or its nominee. Another is senior officer of local self-government at district level. And another is professional medical association or a body within that district. The powers of the district registering authority, what powers this authority has, which is at the district level. It can grant or renew the provisional registration or permanent registration. It has to publish a list of the provisionally registered clinical establishment and also the permanent registrations to invite any objections, etc. It can issue notice, it can enter and search. Then inspection and inquiry can also be done. It may cancel registration. It can immediately restrain a clinical establishment if imminent danger is there. It can recover penalties, and it has to maintain a digital register of district clinical establishments within that district. Then state council is there. State council is at the level of the state. The chairman of the state council is a secretary health, state secretary health. The member secretary of the state council is director health services. It is there are 14 other members. One are the directors of different streams of Indian system of medicine. Then it has got members of medical council, dental council, nursing council, pharmacy council, and ISM. Then Indian Medical Association, paramedical system, and consumer groups and NGOs. The function of the state council are, it is an appellate body against the decisions taken by the district registering authority. Then it has to update and compile the state register. Then it has to send the monthly returns to the national register. And it has to send a representative in the national council. And it has to publish an annual report. So just what are the benefits of this Clinical Establishment Act? One, we are anticipating that we will have a comprehensive digital registry, which will help in policy formulations, better surveillance, response, and management of outbreaks, emergencies, and it will have a better engagement with private providers. The whole idea is not to regulate. The whole idea is to provide proper health care and to collect data for policy formulations. Then uniform standards of category for a particular category. The categorization is very wide and it is there on the website, then transparency is there, process of registration and data will be in public domain. Then multi-stakeholder participation will be there through the consultative process. Effective regulation is also one idea, and improved quality of healthcare. And it is also likely to act as a deterrent against the quackery in the sense that nobody can run a clinical establishment without registration wherever the act is implemented. And only a person having a qualification from a recognized system can run a clinical establishment. Then better management of emergency medical conditions and charges, facilities, etc. would be known to the stakeholders. What are the steps that have been taken by Government of India? A website is there. This is the address of the website, clinicalestablishments.nic.in. Online registration is now functional in 6 states and UT. The process of registration is online available, but those act is there in 15 places right now, but only 6 places the online has been made functional, and Jharkhand, Himachal, and Andaman Nicobar, Daman and Diu, and Chandigarh. Then there are nodal officers and coordinators for implementation of the act. State rules were drafted for the help of the states. A secretariat has been set up. Then budget is provided to the states through National Health Mission budget, through their state PIP for implementation of the act. Initially, a survey was done to assess the situation in the country because the idea was that at least 90% of the existing clinical establishment with small upgradation, they should be able to meet the standards. So survey was done through IMA, and subcommittee, there are 5 subcommittees of National Council who have been working. Categorization and classification, that has been done. A standard template of standard drafted. Minimum standards all drafted. Information and statistics to be collected from the clinical also drafted. And range of rates, we have defined the procedure. The methodology draft is there, and the procedures for which we are not looking at all the procedures, but some common procedures for which a range of rate is going to be prescribed. Then in other states, Maharashtra and Goa, they are also in process of repealing their act and enacting the one on the lines of the Clinical Establishment Act. There are Kerala, Gujarat, Punjab, Haryana, in fact, has drafted the act. There is, I think, some problem. And Meghalaya, they are also in process of defining. Then almost out of these 15 places, only the 11 places they have notified the rules, but UP, Mizoram, Chandigarh and Lakshadweep, they have yet to notify their state rules.
Anil Kumarji, we'll just wind up quickly because...
Just 2-3 minutes.
Because the crux you've already explained.
Okay, fine. This is the standard template under which the minimum standards have been drafted, that is, which includes definition, scope and services of the clinical establishment, physical infrastructure, human resource, instrument, equipment, support services, supplies, legal requirements and records, maintenance and basic processes. These are the supports that are available, and this is the current situation of online registration. Roughly 7,600 clinical establishments have registered online, and around 500 to 600 offline registrations are there. So they are already, the process is on in these states, and so we can analyze these data. These are the main issues. I'll just read out. The slow implementation by many of the states and lack of interest and ownership at state level. Capacity for online registration in districts, in some of the districts, is limited. Then fear of misconceptions, court cases, quacks are also trying to register through online process, that we are trying to take care. And then there are issues with alternative medicines. Are they recognized? Then regulation of unqualified practitioners, paramedical, whether they can practice independently, chemists prescribing the medicines. Then So what we aim is that we aim for a proper health care for the citizens of the country, which is freedom from errors, and best practices are to be given through the standard treatment guidelines, and errors we expect through the minimum standards, and a great service by following the standard treatment protocols and processes. So the call is we can work together and try to achieve it through this act.
Thank you.
It is possible. Thank you.
Thank you, Anilji. Dr. Utturi, your comments, please.
Good afternoon. I think to talk after Dr. Ved Prakash, who is our guru, it's extremely difficult. And thank you, sir, for having some problems that were there with us. We have tried to clarify, but then I think with an open mind, we request you that some things that apprehensions we still have, please try to solve that before anything happens, because we have done that in Maharashtra. I'll just talk about what happened in Maharashtra. We were also extremely apprehensive when we read the Central Clinical Establishment Act. And there was a huge hue and cry opposition to that. But then we sat together and we came to a conclusion that Clinical Establishment Act was going to come sometime in the future. And that is where IMA took a decision, and we tried to find out what were the objectionable things that were there or clauses were there in this Clinical Establishment Act, and what we could do as far as Maharashtra is concerned. Luckily for us, health is a concurrent subject, hence the states have got the right to either not accept this Clinical Establishment Act or to modify it as per the requirements of the state. So we took advantage of that and we tried to do something different in Maharashtra state. And what were some of the things that were objectionable? If you see in the past, right in 2007, this was rejected. And when it was rejected by the Planning Commission, what did they say? They said that investments required to comply with standards might have a spiraling effect on services costs in the health sector, which they did not want. Then, of course, setting up of administrative paraphernalia for inspection has to be discouraged. These were the two main things that the Planning Commission said way back in 2007 when that was rejected. But then somehow this was again brought into the forefront. And what would happen if in the present, whatever the Central Clinical Establishment Act is there, what would happen would be that definitely the requirements, that is the standardization, the minimum requirements for personnel, for infrastructure, etc., if you take into consideration, because sir has already said that almost 70+% of OPDs and almost 60% of IPDs is taken care of the private sector. So obviously, if you have to go on making some laws and rules to increase this infrastructure and personnel required, the healthcare, which is already expensive, is going to definitely increase. And that is what we basically did not want. Then another thing was, contentious issue was the standardization of treatment. You are aware that in medicine, there are multiple modalities of treatment of a single disease. So what we wanted, did we want standardization or did we want a protocol as far as treatment of that particular disease is concerned? So we had to think on those terms also as far as this, because one thing you remember, once it comes as an act, it is a law, you have to follow it. We burnt our fingers in the past in the PCPNDT Act. We burnt our fingers in the past when the CPA came in. We never opposed that. We never tried to put our collective thinking hats like what we are doing today. And that is why our colleagues are today suffering definitely because of that. We didn't want that to happen in this act. Then of course came the thing of stabilization. Extremely difficult. We went through all the dictionaries, what exactly is stabilization. So, simple example I'll give you. If a patient comes in hypotension, she's got, say, a obstetrics patient where she's got a ruptured ectopic or something, the only way to stabilize her is to operate on her. So how is the Clinical Establishment Act, which does not have the infrastructure or anything, are going to stabilize this? Even if it is an endo facility is there. If you do not have a gynecologist, How are you going to do that? I know they say as per the personnel which are present in that particular institution, but we are talking about 10 years, 15 years in future. What happened in CPA when CPA said the compensation was so less, but today, 14 crores compensation. It is not only the doctor, but his whole family and one generation who it is impossible for them to give 14 crores. So that's what we do not want. Then if you see, what had the preamble said? If any act or any law comes in, there is a preamble. This was way back before 2007. It stated that the state must set apart substantial money for purpose of reimbursement. The scheme must provide for the procedure for reimbursement. I do not see any word in the latest act which talks about this. Because today we are supposed to treat free of cost. I'm talking about, since morning what we are talking about, the emergency treatment purposes. We are not saying we will charge the patient, but the state has to take the onus on itself to compensate the doctors, to reimburse the doctors once they take care of this emergency. Then, of course, filing of objections, especially this is a big problem in metropolitan cities and in Mumbai especially, where they say that the authority shall cause to be displayed for information of the public at large and for filing of objections. I don't know if you all are aware that in Mumbai we have a lot of problems where extortion of doctors takes place, and this is again going to open a big Pandora's box if the public is allowed to bring in objections as far as, because if you have the authority who's supposed to register your institution and in black and white you have put down what are the requirements for registering, why do you require to put it up into the public domain at all for objections? Because you have got the rules and regulations which are already set in. Then of course the penalty factor. These are only the few main highlights that I am putting where we had an objection. The penalty factor, which was extendable up to 5 lakhs. Now you tell me in which other profession or which other this you are up to 5 lakhs, we are not criminals, sir. To pay 5 lakhs, there are some small infractions for which we can be pulled up as far as the Clinical Establishment Act are concerned, and for that we have to put a heavy penalty. So, and even if knowingly serves in a clinical establishment 25,000 rupees. In simple thing, if I am going for a visit to see a patient in any institution, I am not going to ask him, are you registered for Clinical Establishment Act? Only then I will enter your institution. See, you have to think about the practical aspects at the ground level as private practitioners, what we will be going through in the future if this act comes into play. And for that, where I go there and I get charges of say 1,000, 2,000 at the most for the visit, if I have to pay 25,000, I will stop. People will stop going to the institutions to go and give their advice. The good points, of course, as he said already, preventing quackery and of course laying down the standards at present which are not present as far as the hospitals and the laboratories are concerned. But the bad points, solo practice. As far as a single doctor is concerned, he has got a small consulting. You don't expect him to have all the requirements, paraphernalia that you are going to bring in the rules and regulations. So you should, I agree that you require to have a registration process for that. We are not saying no for that, but not for the rules and regulations of the infrastructure and personnel required. Then of course, again the license Raj, that is what we do not want. And what about the establishments which are already there, existing, which is there, like for instance in Maharashtra we have the Bombay Nursing Home Act. We are under the Bombay Nursing Home Act. What about those establishments? Nothing has been said. They say you repeal the old act, you bring the new act. So what about 40, 50 years old institutions who are already working under the act? So then we got together, we approached the government. Luckily the government, after a lot of cajoling, listened to what we said. And then they agreed in Maharashtra that what we require to do is to bring a Maharashtra specific Clinical Establishment Act. The draft is ready and we have already given it to the government. What we did, or what the government of course did, was they brought into this preparation of the draft every aspect of the health sector, all the stakeholders. When I say every aspect of the health sector, I mean it was not only the doctors, but it was the patients group also which was there, the Citizens Forum for Patients, the Citizens Forums for Women were there on that group. We had the government people because this was ultimately under the aegis of the health sector, health secretary, and everybody sat together. It was almost a huge group of 17 individuals from different sectors who sat together, which was when we when we started it, they said it is impossible for 17 people, such diverse people, to come to a single paper. But we sat for almost 9 months, multiple meetings, and in the end we came up with a draft which was acceptable to everybody. Yeah. So, and there are some changes that we have done, ultimately. There are some changes. One thing is what the stabilization clause, because we didn't want that word stabilization, because there is no definition for that. To provide basic emergency medical assistance means, with respect to an emergency medical condition specified in clause D, to provide basic emergency medical assistance within facilities prescribed before the transfer of the individual from a clinical establishment where Indo facilities are available. That means it is that life-saving you compulsorily have to do, but you do not require to do everything till you stabilize completely the patient, if you do not have the infrastructure to do. Then, of course, the local registering body, what we did, we wanted, today, as you know, there are almost every individual hospital requires 40 different regulations that are there. What we did is that we brought in the Pollution Control Board, we brought in the fire safety, the F&D administration into that, and we have said that there will be only a single window registration as far as Maharashtra is concerned. That is all. So that, because all these people are on board who otherwise it's very difficult to go individually and take their permissions. Then, as you know, suddenly when the Clinical Establishment Act comes in, there will be thousands and thousands of people who will be giving their registrations, and it is impossible as of now for the government machinery to take care of that. So what we have put, and what do these, this for provisional, obviously there is not going to be any inspection, but we have put in the clause that within 30 days, if we do not get anything back from the government, it is deemed to have been registered. Even as far as the permanent registration is concerned, that within 60 days, if they don't give us a permanent certificate, they don't say that you are given or you are not given, it is deemed that you have got the permanent certificate, so that the clinical establishment can go on working. Then display of information, we have removed that public objection. You can display. If there are objections, it will be taken care of, but we do not want it that specifically to be said that the public to give their objections. In the appellate authority, of course, we have members from the doctor community also, so that if it goes into appeal, then we can get proper justice from there. Then penalties. We have drastically brought down the penalties for the first offense from 5,000 to 50,000, which was up to 5 lakhs. That we have brought down. Not only that, even penalties for minor deficiency, we have brought down to 1,000 rupees. So what I would like to request everybody is that if all the stakeholders can get together and come out with a document like this, then you are not going to have any objections in the future, because all the stakeholders are on board. This is my only request, and whatever I have said, there are a lot of other points, but they are minor things that we have just tinkered with. But this draft has already gone to the government. Unfortunately, the government changed. But the latest that we have heard is it has gone to the Law and Judiciary Department, which is almost the last department to say a go ahead. And we expect that this draft will be there in the public domain very soon. Thank you.
Thank you, Dr. Utture. Advocate Balaji, are there some comments that you'd like to make? Yes, Anilji, you can respond, but after I get a few comments from the floors, I'd like to now request Dr. Vasisht to please some comments, and then I'll come over to Dr. Saini.
See, the spirit behind the act has been very good. The preamble is good. But what happens in India? लड़की है, मैरिज करनी है, पढ़ी लिखी भी है, but she is not consulted. Somebody else decides with whom she is going to marry and living the rest of her life. That has actually happened. It was not, yes, it was not open for comments by the stakeholders, unfortunately, number one. Number two, we were talking of comprehensive. Earlier in the breakout session, we had lengthy discussion. See, there is conflict of law. There is multiplicity of the facts, and this leads to confusion and conflict between the laws. See, at one place, there is an acid burn where you have to treat mandatorily as per the directives of the Supreme Court. On the other hand, there is MCI. I do not know what purpose it has served to our nation. It is best abolished. See, the country will be saved, and there will be best thing we can have is abolish MCI, have unified medical code, and hence on, everything related to medical practice should be governed by a single law. Otherwise, in emergency, CA demands that any patient should be taken care of emergency till stabilization. Delhi, State Commission, Consumer Forum State Commission, gave in a judgment where an emergency patient of acute coronary syndrome was treated by a physician, and it was held that he was not competent because he was not the cardiologist. So please deliberate on those points. Thank you very much.
Thank you, Dr. Vasisht. Dr. Saini, please.
I think rightly said by Dr. Vasisht, हमारे यहाँ लॉ बनता है, जो स्टेक होल्डर्स होते हैं उनको कभी पूछा नहीं जाता. Now, I just one thing against that, what you said was, and preamble. You said preamble was good. I have an objection on a preamble also. First preamble says, first point is, medical profession is unregulated. My lawyer friends are there. More than 70 rules and laws are applicable to medical profession if I want to open a clinic or a nursing home or something else. What more rules and regulations you require? You tell me. You can modify those things. If there is some flaws in some there, you can modify. Rather, you try to curtail those rules and regulation rather than bringing a new law. That is a concern for all of us. And to our lawyer friends also and to the government also, which Dr. Anil Kumar is representing, no professional body will be against the quality. But quality has parameters. In India, when we talk about affordable, accessible, quality healthcare, the quality will be different. Can you fix a price? Can you tell me, or government of India can tell that the price, the money spent on a AIMS per bed and a municipal corporation bed in a Bombay hospital is same? It is different because the quality of service being provided is different. If I am traveling in a train, I am in a general compartment, or I am in a reserve category, in a reserve seat in an AC compartment on a two-tier AC, a two-tier or three-tier, there is a different quality is there. How you can fix a price? And my lawyer friends are there. Can you say that a person with experience of 30 years, a person with experience of 10 years, a person who is representing in a Supreme Court, a person who is representing you in a High Court will have the same charges? Justify that. It is a professional fees which is somebody expecting, and somebody who is doing in a suburb in a Mumbai and somebody in a rural area, the cost of the land, the some concession given by the government at that point of time will be different. If one parameter is there, that about the quality, we are for it. Indian Medical Association has given itself, you rightly pointed out, that we ourselves have gone to have the minimum standard. And minimum standard, what we did, we are talking about evidence-based study. So we did a survey with the consent of the government, that let's go out and see what are the standards which are available, because quality is different places. And every citizen of this country has a right to have a different quality, depending upon status, but the minimum standard has to be there, for which the services has to be provided to each and every citizen of the country, basic medical service to be given. So we did a survey with the consent of the government. Let's talk about minimum standard, even with a single practitioner doctor also. Based on that, We created minimum standards. Let me the minimum standards being brought out. But why so many other laws when 70 laws are already in existence? Let's make single window. I really compliment my Maharashtrian IMA state people that they have been able to convince. I think similar things are required, but we need the support of the other society also, including the lawyers. Just one or two things which I just like to, I already highlighted, fixing of consultation is, I think, absolutely cannot be possible. If any other profession has done it, please tell us, we will like to accept that. Then is stabilizing of patient. I just go beyond that. Stabilization is not only that if you have the facility, maybe you have the facility. Who will pay for that? Suppose this is a super specialty hospital. For that, stabilization will be different. It will be even doing a neurosurgery. And as I said, there is every chance because the government itself is pointing out that 70% of the service are being provided by the private sector. So out of 10, 7 will land up in a private sector. And if happens to be a super specialty hospital or a middle level hospital, the cost, because you all will agree, 40 to 50% of the beds are occupied by emergency patient only. And if all these emergency patients are coming and out of that 70% do not pay, what will happen? Because this act does not talk. We thought that it will help to grow the society, grow the medical profession. But unfortunately, these things have not taken into consideration. When I think my lawyer friends I again put a question on you, my lawyer friends. Whenever we want to bring, and to my government people also, whenever we want to bring a law or something like, for whom? It should help the society, or it should help those for whom you are bringing the law, or it should upgrade the system. You tell me, with this law, if into all the provision of this law is taken, is it going to help anybody? As we see, the medical services are going to be, either it will be higher in price or the medical services will close down. If the 70% of the medical services will close down, what will happen to my common man? I have taken an oath when I took a medical degree that I am for the medical profession, and I have to serve my poor people also. I have to give a basic medical facility to my common man. I'm committed to it. I want the same commitment from my government. Let's bring that 30% which you are providing. Let's come to a level player field. You come to 70%. We'll accept whatever you are, so that my common man is not affected. Secondly, we are talking about fixing up the prices. Number of times we have written. Is there any record with the government? Because when we are tying off the price, always say the private practitioners are charging very high. There has to be some standard. That when you are comparing certain things, we say one cold drink is higher than another. We know the price. Here the price will be what is the cost per bed in a government sector. What is the delivery charges in AIMS or in a municipal corporation bed in maybe anywhere in the city? What is the cost of appendicitis or doing a surgery somewhere? What is the cost of per bed in ICU in a government setup? You bring that cost to us. And I am 100% sure our people will abide that cost. Then you come and say that fix up your prices or a range of cost. Till that time, I think it is absurd. So our humble submission is, sir, we are not against any law. We are not against any regulations. But please enforce those laws which are already there. We are talking about that this will help in eradicating the quackery. I was president of Delhi Medical Association. At that time, we didn't have a council. We had a meeting with the health minister. He said, we want to bring this council because this will eradicate quackery, because those who will get registered, they will be able to practice. Those who will not be able to get registered because they do not have adequate qualification, they will be called quacks, and they will not be able to practice. Their clinic will shut down. What has happened? during this 10 years, they have multiplied 10 times. Nothing has happened. So, my request will be a humble submission to you, and with the support of my lawyer friends, let's build up the system. Let's make our system, which is already there in existence, stronger. We are committed to serve the humanity. We are committed to serve the common man of Indian with our all the resources we have. And mind you, there is in the mind of people that private practitioners are earning a lot. But if you see today, the scenario is 40 to 50% of the small hospitals, which are less than 50 bedded hospital, they are on the verge of closure. And if this happens, this will again affect a common man. The dream which we have, the dream our national leaders have to providing affordable, accessible healthcare to everybody will be lost. Thank you so much.
Thank you, Dr. Saini. I think we've got a lot of it summed up in all these 5 expert people speaking. I'm just going to give the mic to Dr. Utture for a minute. He wants to discuss on reimbursements, and then we're going to have a wind up from my side.
Thank you, Parag. Because of paucity of time, I forgot to tell you, Dr. Saini, in our draft 49B, it is said, in case of basic emergency medical assistance given to unknown person, known persons are supposed to pay, it is there. Unknown person or unidentified patients, cost shall be reimbursed by the government as per its prescribed. Reference as per recommendation of Law Commission report. It is there. As far as the professional charges, that is also there. What we have said is we have not mentioned anything about the professional moratorium on the professional charges, but we have mentioned that every clinical establishment will have all their charges in a booklet form at the reception, which will be ready over there for reference of the patients, and then it will the patient's prerogative to go to that clinical establishment or not. So that compulsion, we have said that it will be there. There's no question of putting up on all your walls and boards and everything your charges.
I want to clarify. I think every patient has a right to know, for which we have no objection at all, that whatever charges I am taking, I am bound to display those. I think there's no issues on that. Thank you so much.
That's fine. I think on the modality of how to display and all that is secondary. I am, in all fairness to my senior colleague from the government of India, I think we need to listen to him for about 3 to 4 minutes. He has, I won't call it a rebuttal, but he has what he believes is the right thing in response to all our comments, and I think that will seal the discussion here, and then we can decide what to take forward as an outcome of this for the 18th. Dr. Anil Kumarji. Sir, please, it will be easier, sir. Also allow me to cut you off at some point.
Yeah, sure. Actually, the points raised by IMA, they are very well taken, and they have been raised many times in the past also. But some of the, like fixing the prices of the procedures, it is the range of rate we are talking about but that is introduced, that was not there in the main act, that was introduced in the rule. And that perhaps can be, if it goes as a recommendation from a body like this, then it can be changed at the ministry level, because we are also facing difficulty and we are always facing this resistance from that government should not try to fix the prices, but we are talking only fixing the price of the procedure only, and it is not fixing, it is giving a range. Okay, even that is acceptable. It is yet not even fixed price of one procedure, so don't worry about it. Don't worry about it. Second is the laboratory, because why it was required. The Dr. Saini said it is already over-regulated. But in a metropolitan, like a capital of the country, if you see anybody can open a laboratory, even if he doesn't have any qualification. Just under the Shop Act, you can open a laboratory in Delhi, and there is nobody to regulate that laboratory, whether they are actually doing tests, where they're doing it as per the SOPs, or there is no regulation on the laboratories, on the Ayush system. So all those we are forgetting. So it was all unregulated part, which is there even in the national capital. Then second is another point they said about the inspection Raj. The inspection Raj point is that why we are wanting the things to be displayed in public domain, because the inspection is not mandatory as per the Act. It is required only in certain cases. The district registering authority will decide it. And if there are certain objections to certain clinical establishments, then only the inspection would be undertaken. That's why the objections were invited. And it is not mandatory under the Act. That I may like to clarify that. And then solo doctors, yes, that solo doctor, we also think that it is, but that flexibility has been given to the state government, that they can decide to implement it to the number of categories they want to implement it, or to the system they want to implement it. So state government has that flexibility under the Act itself. And then another is stabilization. The definition is there in the Act, but that may be controversial, though reimbursement system, because the central government cannot reimburse from the, it is a state subject. So that issue can be taken up with the state government. That issue can, it is a state's, health is a state subject. It is not a central government subject. As per the Constitution of India. Just a minute, just a second.
Let him finish.
Act doesn't prohibit anybody to take. Central government cannot do everything, can take care of the entire country. Actually, it is a.
Okay, Anilji,
just one or
yeah, last one.
Yeah, one more point. Actually, this 5 lakh penalty, which the Maharashtra people found high. In fact, there is a contrary view to this from the Rajasthan. They want penalties to be increased. They said 5 lakh, jo unqualified person, he will pay very easily 5 lakh rupees and he will move to another setup. You will not be able to regulate the unqualified by, it is very small deterrent to those. And in fact, I tell you about the Himachal Pradesh, we have been able to stop electro-homeopathy practitioners from practicing in Himachal Pradesh. If there is a Maharashtra person, there was a Himachal Pradesh person over here, and he can vouch for it, that the there is a 2-bedroom, MIG flat in Delhi in Janakpuri, which is given a degree of electro-homeopathy, and that they've given, I think, 50,000 degrees, and these people are practicing all over the country, which nobody could control. In Himachal Pradesh, they have been stopped from practicing. Even the court favored them. But after the implementation of this act, they have been stopped. So it is it is really a deterrent, because you cannot practice. There is no statute under the Delhi Regulatory Council why it is not working, because there are other systems, there are laboratories which are unregulated. So thank you.
Anilji, I think I'm going to end this here, and I'm going to, sir, we are going to break for refreshments now. I think the one thing that has not come out this very, very strongly is the fact that as a country, we needed a Clinical Establishments Act. And I think the first word here in our discussion point was supposed to be compliments. While we understand that the width of the Act has gone a little bit beyond what it was supposed to serve, as a Clinical Establishment Act, probably it makes sense to have an act which regulates this. I think they've gone a little bit too far with the search and seizure, with the fees, with who can do what, with regulating everything. Money is something which you should generally not step into an area where there is public and private enterprise coexisting reasonably peacefully, where 70% is today borne by the private sector. So I think there are certain qualities, something for which there is a body in the country, Quality Council of India, which surprisingly has been set up to establish quality standards in the country before the regulatory environment even came into being. So I think there is a little bit of fine-tuning to be done, and I'm sure that over the years we will see some of this coming forth. But at the very outset, I believe that while there are many comments and many complaints with this clinical establishment, over time we will realize that it is something which is required, and it's something which is a very big hygiene factor.